Hey, yo, peace, fam. Welcome back. So you've all been with us through every deep dive, every exposed narrative, and every fight for the truth. And because of that loyalty, we're able to level up today. Today makes a big moment for our community, for our channel. We're evolving, we're expanding, and we're taking this mission to a whole new level. This next level requires a new name, but it's still the same mission. First up, the big announcement, Flesh of the Gods is now officially The Source, FOTG. Now, I know some of you are attached to the old name, and believe me, so am I. That name means something. It represents the raw, unfiltered truth we've always strived for. And that's exactly why FOTG is staying right there in its roots in our foundation. But The Source is about clarity. It's about letting everyone, new and old, know exactly what we are. Your most interactive, trusted source for legal analysis, for exposing hidden truths, and for understanding how justice is truly served in this digital age. This change allows us to grow, to reach more people who are hungry for the truth, and to become the go-to platform for this crucial conversation. We are not changing our mission. We're just making it clearer, stronger, and more accessible. Appreciate y'all being here. Stay fresh, stay blessed. Let's get into it.
The hell, Bobby? Where my intro at? It's gone. What up, family? What up, brown sugar babe? I see you. Appreciate you joining, family. This thing's supposed to be playing my intro. See, that's why we out here testing right now, getting everything set up, figuring out the do's and don'ts. But anyway, let's get to it. What up, Ali? I see you. Appreciate you joining, family. Where's my intro? It's really gone. What? That's crazy. I guess I had to do the old one. That's crazy. Oh, this one ain't working. What the hell, Bobby? All right.
Robert Brooks was transferred from Mohawk Correctional Facility to Marcy Correctional Facility on December 9th. Now, less than 24 hours later, he would be dead. I did watch the video, and it's graphic. It shows Brooks being kicked, punched.
Well, isn't this a nice surprise?
We getting it together, family. We getting it together. Don't worry. We run the old outro for now. What up, Ali? What up, brown sugar? I see y'all. Appreciate y'all joining. What up?
And at one point, partially stripped, all while being handcuffed. Partially graphic, and 24 hours later, he would be dead. I did watch the video, and it's graphic. It shows Brooks being kicked, punched, and at one point, partially stripped, all while being handcuffed. Just before 9:30 on December 9th, body cam video shows Robert Brooks in handcuffs being led into the infirmary at Marcy Correctional Facility. Corrections officers are then seen carrying Brooks into the lobby. He is then taken to a medical exam room. There are multiple corrections officers surrounding Brooks. A few minutes into the video, we see the beating begin. Video showing a guard begin punching Brooks while other corrections officers are seen looking on. Video then shows guards holding Brooks down while another guard appears to kick him in the groin. Multiple officers continue to hit and punch Brooks. Video also appears to show a guard grabbing Brooks by his throat and picking him up while another guard continues to hit Brooks in the stomach with a shoe.
Now, I don't know, but to me, that definitely looked like some RICO activity because they didn't report it, nothing. They was covering up for it. It was 10 of them there. That's definitely more than 3. So why is there no types of RICO anything? But anyway, let's get into it. They was in court today. We could get into some of that. Appreciate y'all being here, family. Let's see. Let's play this first.
4 months ago, an incarcerated man from Rochester died following a beating by corrections officers caught on body-worn cameras. Robert Brooks's family left to navigate the unthinkable.
We've been hurt, we've been heartbroken, but we also are finding the silver lining into this situation because now we have a voice and we want to use our voice to help millions and everybody else out there in the future.
Robert Brooks Jr. and his family filed a civil lawsuit in January against 17 individuals, including Docs Commissioner Daniel Marticello. A motion was filed by the state attorney general last week to have claims made against Marticello dismissed because of failure to allege his personal involvement in the violation of Brooks's constitutional rights.
It's not surprising just because we've been in these meetings, we've been sitting down with people, and it's like no one wants to take accountability.
Last month, a similar incident reported right across the street from Marcy Correctional Facility at Mid-State Prison.
I was furious. When it first happened, I was furious. I didn't know what to think.
Per the indictment, 10 corrections officers are charged in connection with the fatal beating of 22-year-old Messiah Nantwi.
Right. And don't forget, they killed this one too. Right there, right next door to the Robert Brooks. They killed Josiah also. All right, let's get into their court here. And it's a little bit slow, but it needs to be watched. 4 of them pled guilty. 4 of them took pleas. 4 of them took pleas and pled guilty, and 4 of them is trying to take it to trial. So it's a little bit slow, but we gonna rewatch it, family. Let's get it.
The matter of the people against Nicholas Anzalone, indictment 25035. This matter is on for a final pretrial conference today with the defendant's jury trial scheduled to begin 2 weeks from today. It is my understanding, however, that the parties may now have arrived at an agreed upon disposition, and I'll state my understanding of that proposal. That the defendant will be pleading guilty to count 2 of the indictment, charging the felony offense of manslaughter in the first degree, and the agreed upon sentence would then be 22 years in state prison along with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges that would satisfy the remaining counts contained in the indictment. Is that people's understanding?
It is, Your Honor.
Mrs. Franco, that's your understanding?
Yes, Your Honor.
Mr. Anzalone, is that your understanding of the proposal, and is that what you want to do here today?
Yes, Your Honor.
Please raise your right hand. You now swear you will tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, Your Honor.
You may put your hand down. So, Mr. Anzalone, I'm going to ask you some questions now. These are to help me decide if I can accept your plea. If at any time you do not hear a question, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay?
Yes, sir.
Do you understand by answering my questions and pleading guilty here this morning, you're giving up your right to remain silent and to not incriminate yourself?
Yes, sir.
Have you spoken with your attorney about your case, about pleading guilty and thereby waiving your right to have a trial?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
Have you had enough time to speak with your attorney about your case?
Yes, sir.
The charge order to plead guilty to pursuant to this agreement is count 2 of the indictment, charging a felony offense, manslaughter in the first degree, which is in violation of Penal Law Section 125.20, Subdivision 1 and 20.00. It is alleged here that on or about the 9th day of December 2024, in the town of Marcy, County of Oneida, acting in concert with each other, your fellow corrections officers, co-defendants named in this indictment, intending to cause serious physical injury to another person, you did cause the death of that person. Specifically, it's alleged here that each of you defendants participated in the multiple beatings of incarcerated individual Robert Brooks, which resulted in his death. Is that true?
Yes, Your Honor.
Mr. Fitzpatrick, did you want anything further?
I'm satisfied by the allocution, Your Honor.
Mr. Anzalone, how then do you plead to that second count, manslaughter in the first degree, guilty or not guilty?
Manslaughter is insane. Like, it was an accident. That was very clearly murder. Y'all sit there and beat and tortured this man, dragged him out by his cuffs, carried him by his handcuffs, beat him, didn't do nothing to him, put him in the corner, beat him some more, and then y'all talk about some accidental manslaughter. Man, that's some...
Guilty, Your Honor.
How old are you now, sir?
44.
Can you read and write the English language?
Yes, sir.
Are you a citizen of the United States?
Yes, Your Honor.
Do you have any physical or mental problems that could prevent you from understanding what you're doing here today?
No, Your Honor.
Did you take any kind of drugs, medicine, or alcohol before coming to court that could affect your understanding?
Monkey shit.
Just take diabetes.
Okay. Does that in any way affect your understanding? Are you clear-headed as you stand before me today?
Yes, Your Honor.
And that's crazy. And then they want to give everybody else like the maximum sentence. They want to, even when people ain't even committed the crime, they want to lock people under the jail for stuff that they ain't even got no proof for. But here, when we have proof y'all did it, we got it on camera and all the stuff, y'all want to give them the most lightest sentences as possible. That's crazy. Why? Just because they got a badge on? They should be having worse sentences. They the ones that's supposed to be protecting people, not killing people. That's the opposite of your job. You should have way worse sentencing.
You're not currently on probation or parole, correct? Now, by pleading guilty, you are giving up your right to have a jury trial. Do you understand that?
Yes, Your Honor.
At a jury trial, you would be presumed innocent and would be entitled to the following rights: to be represented by your attorney, to confront and cross-examine witnesses presented by the government. You'd have the right to remain silent and not incriminate yourself. You would have the right, but not be required, to call witnesses, or you could testify on your own behalf. You would also have the right to require the government to prove your guilt beyond a reasonable doubt to a jury of 12 people who would have to be unanimous in finding you guilty. You understand you have each of these rights, and by pleading guilty here today, you're giving up each of these rights.
Yes, Your Honor.
You understand by pleading guilty, you're also giving up any defense you might have to these charges.
Yes, Your Honor.
Now, pleading guilty is the same as a verdict of guilty, rendered by a jury after a trial. You understand that?
Yes, Your Honor.
Other than the plea and sentence agreement I spoke of earlier, has anyone made any other promises to get you to plead guilty?
No, Your Honor.
Did anyone threaten you or force you to plead guilty?
No, Your Honor.
Have you entered this plea today voluntarily and of your own choice?
Yes, Your Honor.
While you're incarcerated for this felony conviction, you will not be eligible to vote in an election until such time as you are released. You understand that?
Yes, Your Honor.
Lastly, sir, part of your negotiated plea does require that you waive your right to appeal.
What up, no one? What up, Michelle B? Let me put this on regular speed because they talking too fast. It's kind of hard to hear. But what up, Michelle B? I see you. What up, no one? Appreciate y'all joining. Y'all see this? Insane, family. Oh, and something I think Michelle said what the other four plead to. It's all part of the same charge, so they all pled to some type of involvement with this case. But I haven't seen it yet. It's coming up. I haven't played them yet, so they all coming up.
A separate and distinct right to appeal a judgment of conviction to a higher court in Rochester known as the Appellate Division. There you can, with your attorney, and a free one if you cannot afford it. You can file a brief and argue before that court that there exists some problem with your conviction here in this court. That is a right you have. It's also a right you can waive or give up, and it is being required that you waive your right to appeal. On condition, I give you the sentence promised to you. That means your conviction and sentence in this court will likely be final, so there's then little you can do to go back after the fact and try and change that, and you will have thereby significantly limited your options for appeal in the future. Do you understand?
Yes, Your Honor.
Have you spoken with your attorney about waiving your right to appeal?
Yes, Your Honor.
Do you then agree to waive your right to appeal on condition I give you the sentence promised?
Yes, Your Honor.
Are you doing so voluntarily?
Yes, Your Honor.
I'm holding up for you a document entitled Waiver of Right to Appeal. Halfway down the page, I see the signature, Nicholas Anzalone. Did you sign this document here after reviewing it with your attorney?
Yes, Your Honor.
Based upon the defendant's statements and misdemeanor here in court, I find a knowing voluntary plea with a factual basis. I will direct the clerk to enter the plea into the minutes of this court, and we will adjourn the sentence until November.
So he took that plea, and also, so he getting like 20-something years. I think 22 years or something like that. But also, we did play the other cop prior to this. Maybe I'll pull some of that up after this. The other cop had already had this hearing too. So it's actually 10 of them. One of them was separate from this case, but they brought all 8 of them in today. All the remaining 8. And I don't know what happened to the other one yet.
21st. November 21st, 9:30 a.m. for sentencing. Does Mr. Anzalone wish to remain out?
Yes, Your Honor.
All right, Mr. Anzalone, you did post a significant $250,000 bond with this court, so I'm going to allow you to remain out pending sentence on that basis. However, I'm attaching 3 conditions as part of our plea agreement. Condition 1 is you have to meet and cooperate with probation as they prepare your pre-sentence report. Condition 2, you have to come back here to court on any date you are required to be here. As of right now, you know that's November 21st at 9:30 in the morning, you'll be sentenced. The third condition is You must commit no new offense. There are to be no new arrests of any kind between now and the time of your sentencing. Added to that, there's to be no contact with any of the witnesses in this case. There's to be no interference of any kind with your co-defendants or with witnesses as this matter continues on to trial. Do you understand each of those conditions?
Yes, Your Honor.
If you fail to abide by one or more of those conditions, then I would not be bound by the sentence agreement. I would not permit you to withdraw your plea, and I would then be authorized to sentence you to any term our law permits, up to and including the...
So check this out, right? He just pled guilty. It gave him 20-something years. But he told him, I'm going to let you stay out until November 21st. You get to stay out 2 more months before you go because you paid this $250,000. So what? You found guilty. That don't matter. Take his ass to jail. Why is you giving him 2 more months to decide if he want to run or not?
the maximum term in state prison. Is that understood?
Yes, Your Honor.
You speak with probation on your way out this morning. I'll see you back here November 21st.
Judge, just if I can, to the extent that Your Honor requires in order of the court for us to participate in the probation department proceedings, we'd like that order of the court.
Y'all do know there's been a lot of mass shootings and type stuff going on, right? Y'all shouldn't just let people out who've been convicted for 20 years. Y'all don't do that usually. Why y'all doing it for him?
Necessary.
For you as counsel to participate?
Correct.
Try to give him a chance to go and do if he want to get grimy. He know he going to jail for life. He could go do all types of stuff between these 2 months.
Do so.
Great. Thank you, Judge.
¿Qué puñetas?
Anthony Farina.
Marcy.
Tell everybody, well, I still fight through the devil, man. Like you said, you trying to bitch over that. I gotta get you what they want, man. I mean, people want the real, man. It's time for the real people to continue to be in position.
This is the matter of the people against Anthony Farina under Indictment 25035. This matter is on for a final pretrial conference this morning. However, it's my understanding the parties have now arrived at an agreed upon disposition, and I'll state my understanding of that proposal. That the defendant will be pleading guilty to count 2 of the indictment, charging the felony offense of manslaughter in the first degree. The agreed upon sentence would then be 22 years in state prison, along with 5 years post-release supervision, a waiver of appeal, and surcharges. That will be in full satisfaction of the remaining counts contained in the indictment. Is that the people's understanding? Wait,
I gotta run it back. He said 15 years for what? What is his charge? I'm sorry, I missed it. I was reading Ali comment. I gotta rewind that a little bit.
This matter is on for a final pretrial conference this morning. However, it's my understanding the parties have now arrived at an agreed upon disposition, and I'll state my understanding of that proposal. That the defendant will be pleading guilty to count 2 of the indictment, charging the felony offense of manslaughter in the first degree. The agreed upon sentence would then be 22 years in state prison, along with 5 years post-release supervision, a waiver of appeal, and surcharges. That will be in full satisfaction of the remaining counts contained in the indictment. Is that the people's understanding?
That's correct, Your Honor.
Mr. Riallo, that's your understanding?
It is, Your Honor.
Mr. Farina, is that your
So his offer, 22 years for manslaughter. Again, another one.
understanding of the proposal to resolve these charges? Is that what you want to do here today?
Yes, Your Honor.
Just raise your right hand. Do you not swear you will tell the truth, the whole truth, nothing but the truth, so help you God?
Do, Your Honor.
You may put your hand down. Mr. Freeman, I have questions for you now to help you decide if I can accept your plea. If at any time you do not hear a question, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay?
Yes, sir.
You understand by answering my questions and pleading guilty here this morning, you're giving up your right to remain silent and to not incriminate yourself.
Yes, Your Honor.
You've spoken with your attorney about your case, about pleading guilty, and thereby waiving your right to have a trial.
Yes, Your Honor.
Are you satisfied with the services of your attorney?
I am, Your Honor.
Have you had enough time to speak with your attorney about your case?
I have, Your Honor.
The charge order plead guilty to pursuant to this agreement is count 2 of the indictment, charging the felony offense manslaughter in the first degree in violation of penal law sections 125.20, subdivision 1 and 20.00. Here it is alleged that on or about December 9th, 2024, in the town of Marcy, county of Oneida, acting in concert with your co-defendants, fellow correction officers, intending to cause serious physical injury to another person, you did cause the death of that person. Specifically, you and your co-defendants participated in the multiple beatings of incarcerated individual Robert Brooks, which resulted in his death. Do you admit that to be true?
Yes, Your Honor.
Would you want anything further, Mr. Fitzpatrick?
No, Your Honor.
Mr. Farina, how do you plead to that second count, manslaughter in the first degree, guilty or not guilty?
Guilty, Your Honor.
You are 49 years old, sir?
15 October.
You can read and write the English language.
Okay.
Are you a citizen of the United States?
Yes, Your Honor.
Do you have any physical or mental problems that could prevent you from understanding what you're doing here today?
No, Your Honor.
Did you consume any kind of drug, medicine, or alcohol before coming to court that could affect your understanding?
No, Your Honor.
You're not currently on probation or parole, correct?
No, Your Honor.
By pleading guilty, you're giving up your right to have a jury trial. Do you understand that?
I understand, Your Honor.
At a jury trial, you would be presumed innocent and you would be entitled to the following rights: to be represented by your attorney, to confront and cross-examine witnesses presented by the government. You'd have the right to remain silent and not incriminate yourself. You would have the right, but would not be required, to call witnesses, or you could testify on your own behalf. You would also have the right to require the government to prove your guilt beyond a reasonable doubt to a jury of 12 people who would have to be unanimous in finding you guilty. Do you understand? You have each of these rights, and by pleading guilty here today, you're giving up each of these rights.
Yes, Your Honor.
Do you understand? By pleading guilty, you're also giving up any defense you might have to these charges.
Yes, Your Honor.
A plea of guilty is the same as a verdict of guilty rendered by a jury after a trial. Do you understand that?
Yes, Your Honor.
Other than the plea and sentence agreement I spoke of earlier, has anyone made any other promises to get you to plead guilty?
No, Your Honor.
Did anyone threaten you or force you to plead guilty?
No, Your Honor.
Have you entered this plea today voluntarily and of your own choice?
I have, Your Honor.
While you're incarcerated for this felony conviction, you will not be able to vote in an election until such time as you are released. Do you understand that?
I do, Your Honor.
Lastly, sir, part of your negotiated plea does require you to waive your right to appeal. As a defendant in this court, if convicted, you have a separate and distinct right to appeal a judgment of conviction to a higher court in Rochester known as the Appellate Division. There you can, with your attorney, and a free one if you cannot afford it, file a brief and argue before that court that there exists some problem with your conviction here in this court. That is a right you have. It's also a right you can waive or give up, and it is being required that you waive your right to appeal on condition I give you the sentence promised to you. That means your conviction and sentence in this court will likely be final. So there's then little you can do to go back after the fact to try and change that. And you will have thereby significantly limited your options for appeal in the future. You understand?
I do, Your Honor.
Have you spoken with your attorney now about waiving your right to appeal?
Yes, Your Honor.
Do you then agree to waive your right to appeal?
New emojis alert for the next season. We switched it up. You know what I'm talking about. We got some new emojis. Y'all check them out. We got the source bomb. We got the what ups. We got the source. We got the sustained overrule. We got the scales, groupthink, and a lot more. Speech locked up. Yeah, y'all check them out anyway.
On condition I give you the sentence promised.
Yes, Your Honor.
Are you doing so voluntarily?
I am, Your Honor.
I'm holding up for you a document entitled Waiver of Right to Appeal. Halfway down the page, I see the signature Anthony Farina. Would you sign this document here after reviewing it with your attorney?
I have.
Based upon the defendant's statements and his demeanor here in court, I find the knowing voluntary plea with a factual basis. I will direct the clerk to enter the plea into the minutes of this court. We will adjourn sentence until
November 21st.
November 21st, 9:30 a.m. for sentencing. And does Mr. Farina wish to remain out pending sentence?
Yes, Your Honor.
Go along with that, Mr. Farina, based on the bond amount that you posted with this court previously, the 3 conditions will attach as part of our plea agreement. Condition 1 is you have to meet and cooperate with probation as they prepare your pre-sentence report. Condition 2, you have to come back here to court on any date you're required to be here. As of right now, November 21st, 9:30 a.m. to be sentenced. Condition 3, you must commit no new offense. There are to be no new arrests of any kind between now and...
Hey, Trikisha, I couldn't see what they was, and I forgot. Yeah, a lot more. A lot more.
...time of your sentencing. That further includes the requirement that you have no contact with any of the witnesses in this case or otherwise interfere with the upcoming trial of your co-defendants. You understand each of those conditions?
Yes, sir.
If you fail to abide by one or more of those conditions, then I would not be bound by the sentence agreement. I would not permit you to withdraw your plea, and I would then be authorized to sentence you to any term our law permits, up to and including the maximum term in state prison. Understood? You can speak with probation on your way out this morning. I'll see you back here November 21st.
So he took that plea, coming back November 21st for sentencing. He got his 2 months to walk around outside. All these criminals on the street. What's wrong with them putting all these criminals out on the street like this? All these murderers. They put out 4 murderers on the street. Keisha, the trick is, right, you gotta take a screenshot. Take a screenshot of them, and then you can zoom in and look at them. That's what somebody taught me. Appreciate y'all being here. Hit the like, hit the subscribe. Welcome to The Source. Who's that? Judith GA. What up, Judith? I see you. Appreciate you joining, family. Next up on the cop murder list. Hey, why ain't this enough for a RICO though? Why they don't get no type of RICO for this? That's more than 2 crimes, right? Committed by more than 3 people. That's apparently all it takes for a RICO these days.
No. No, he's sleeping.
This matter is on for a final pretrial conference with the defense jury trial scheduled to begin 2 weeks from today's date. Before I get to the final pretrial matters, it is the court's understanding that there have been further.
So this one of the first ones, I guess that's gonna take it to trial. This is a pretrial for him. It's not the other hearing. This is a pretrial, not a guilty plea.
There are ongoing conversations between the parties, and that a revised offer was conveyed. My understanding of what was proposed was a plea of guilty to count 2, the felony offense of manslaughter in the first degree, with a recommended sentence of 22 years in state prison with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges. Is that your understanding, Mr. Bush, of what you've discussed with your client?
Yes, Your Honor.
I see we should proceed to that.
He wishes to reject the offer.
Mr. Kingsley, you've heard the terms of the proposed agreement, correct?
Yes, sir.
All right, and I believe we've talked about this before, but we understand that you do stand charged with a higher offense, murder in the second degree, such that if you're convicted after a trial of this matter of that higher offense, the law leaves me no option but to impose a life sentence. You understand that?
Yes, sir.
Understanding your exposure, you will not see an offer this favorable again as we go forward. To the contrary, I will not accept any pleas but to the entirety of the indictment with no promises as to sentence. I want to turn down that offer with certainty of 22 today.
Yes, sir.
Mark that offer then as rejected. It's not to be re-extended.
He said he taking it to trial. Hey, I ain't gonna lie though, I probably would too. Like 22 years, that's life anyway. Why not fight it? I ain't getting out anyway.
We can proceed with the final pretrial. Have witness lists been exchanged between the parties as of yet?
We have provided a witness list. In addition to that, an order of proof. I have not received a witness list from the defense.
I did receive the prosecutions and some further correspondence. Do you expect to have witnesses received at this time?
No.
If that changes, you'll promptly inform the court and the prosecution.
Yes, sir, they will.
Mr. English, you'd like the court to give the no unfavorable inference charge about the possibility of your client not testifying?
Yes, Your Honor.
The court will do so. Can you discuss an anti-market waiver with your client?
I have. I have signed it, and he will sign that waiver.
I'll pass the written waiver. Mr. Kingsley, the first order of business when we begin your trial is to select a jury in your case. During the voir dire questioning process of those jurors, you have a right to be present for all of that questioning. You also have a right to remain seated at a counsel's table should any conferences occur outside your presence. If you're going to remain seated, there's a writing you have to sign to that effect. Now I've received this document back, executed, entitled Waiver of Right to be Present During Sidebar Conference, which appears to bear the signature David Kingsley. I'm holding that up for you now, sir. Can you confirm for me, Mr. Kingsley, you did sign this document here after reviewing it with your counsel?
Yes, I did.
The court is signing and approving the waiver as well. I would remind the attorneys that if there are any unusual questions of law or requests to charge, better to bring those up sooner than later to give the court time to review this thing. Also, the court does prefer exhibits marked in advance to the extent possible. I'll remind counsel that during jury selection, do not discuss the law, do not be repetitious, do not make improper appeals to bias, sympathy, or prejudice. There will be a 20-minute limit per panel for the prosecution and initially for the defense, but with as many defendants as anticipate, the court will use its discretion to curtail successive questioning by defense counsel should it become repetitive. Also, the court does intend to permit press access to the proceedings. Copies of the court's standing order regarding that have been supplied to the attorneys for both sides. Are there any objections to what the court's outlined in terms of permitting coverage from the people?
No.
Defense?
No, Your Honor.
Is there anything further from the prosecution?
Judge, do you, on voir dire, handle the concept of accomplice liability in questioning the jurors and see if they'd be able to follow that?
I will address that as part of my preliminary instruction to them, advise them as to the general meaning of that term. Yes.
Thank you.
Anything else, Mr. Fitzpatrick?
No, Your Honor.
How about you, Mr. Davis?
Nothing. Thank you.
All right, in that case, we'll have you all here promptly no later than 9:30 a.m. on October 6th, and we'll begin jury selection for your trial at that time. I'll see y'all back here now.
He get to walk out and just chill till trial. He going to jail for life, man. They gotta lock him up for life, man. He didn't take that plea. That's what, 2-1 or 3-1? I think that's 2-1.
Well, isn't this a nice surprise?
No. No, he's sleeping.
Juden, I think it will be live streamed because most of it has been so far. So I think they'll keep on streaming it as long as someone is there to record it. Because they've been streaming it so far. I think I streamed two different parts about this before. So they have been streaming it. I couldn't find them though. I was looking through my videos trying to find the clips real quick, but I couldn't find it fast enough. Maybe I'll pull it up now while they having sidebars. Keisha said they finally got caught because you know they been messing up inmates. That's a fact, and you know it's been on body cam too. You know they been doing all this stuff. This ain't nothing new. Everything they been doing this year, this ain't nothing new. Will the trial be live streamed? Yeah, Hope Media does have a Rule 22. Yeah, they got the Rule 22. They got it. New emojis in the building. Chikisha said, he said, and a lot more. Yeah. I ain't get the names off. We got the what the helly. We got the mic, the voice locked up with the handcuff, the microphone locked up. We got the monkey shit. You know, it's a couple new ones. Plus the members, TSC, Joni 4. Some of the top stream sponsors, the What Up, What Up, What Up, Alley. Alright, let me fast forward some of this. I'm tired looking at this Santa Claus. That's what Santa look like to me, y'all. Is this what y'all want for y'all Santa? Is this your Santa Claus?
Attorney, I'm going to hold. Mr. Walters, please take a few minutes to speak with your attorney. I'm going to hold your case for a second call. Again, could I get your approach for just a moment, please?
Bruh.
evidence is not the evidence of evidence.
What?
While they getting it together, calling up Matthew Gallagher, whatever his name is. Shout out to Allie. Appreciate you, family. Dropping a 10. I was trying to catch the comment, but I was moving too slow and it slipped on by. She says, shout out to The Source, FOTG, in the most interactive channel, The Source. What up, what up, what up? Hey, appreciate you, family. Y'all show some love to Allie. Drop some what up, what up, what ups and some coins in the chat. We also got some more emojis, too. We got the wrap it up button coming soon, and maybe a new one for the coin. Maybe a new update on the coin. Appreciate y'all, though. Appreciate the love. Y'all show us some love. Shout out to Allie. What up, what up, what up?
Morning, Council. Can I have you approach for just a moment?
The absence of evidence is not the evidence of evidence.
What?
Stay on another sidebar. You know, we might as well send a shout out again one more time while we waiting for them. Y'all show some love. Drop some coins in the chat. The Source, much appreciate you, family. Definitely. Let's keep it going. Some of them I think is gonna come back in towards the end. They gotta get some stuff clarified first.
Your Honor, we approach. Oh, yes, please.
That would be the right front, the right left, excuse me, the right left side. Front.
Okay, all right.
Brooks Jr., who has been busy meeting with reform groups and lawmakers to try and enact change in the prison system, and he says he won't feel okay until his father gets justice. 4 months.
The matter of the people against Michael Magshaw, indictment 25035. This matter is on for a final pretrial conference. However, it's the court's understanding that the parties may have now arrived at an agreed upon disposition. I will state my understanding of that proposal. That is that the defendant will be pleading guilty to count 4 of the indictment, charging the felony offense, manslaughter, second degree. The agreed upon sentence will then be 3 to 9 years in state prison, along with the imposition of mandatory state surcharges. Is that the people's understanding?
It is, Your Honor.
And Mr. Capaz, is that your understanding?
Yes, Your Honor.
Mr. Magshaw, is that your understanding of the proposal, and is that what you want to do here today?
Yes, Your Honor.
Please raise your right hand. You don't swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do, Your Honor.
You may put your hand down.
Respectfully, Your Honor, if I can add, he is not waiving appeal.
Yes, that is part of the understanding. I'll ask you, Mr. President, just step just a bit to the side to let your client step up so that he can be heard clearly through the microphone. Mr. Magshaw, I have questions for you now to help me decide if I can accept your plea. If at any time you do not hear a question, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay?
Yes, Your Honor.
You understand by answering my questions and pleading guilty here this morning, you're giving up your right to remain silent and to not incriminate yourself.
Yes, Your Honor.
You've spoken with your attorney about your case, about pleading guilty, and thereby waiving your right to have a trial.
Yes, Your Honor.
You're satisfied with the services of your attorney?
Yes, Your Honor.
Have you had enough time to speak with your attorney about your case?
Yes, Your Honor.
The charge order to plead guilty to pursuant to this agreement is count 4 of the indictment, charging a felony offense, manslaughter second degree, in violation of penal law sections 125.15, subdivision 1, and 20.00. It is alleged here that on or about December 9th, 2024, while in the town of Marcy, County of Oneida, you did recklessly cause the death of Robert Brooks, specifically yourself, for a significant period of time during the beating of Robert Brooks, was the ranking corrections officer in the infirmary emergency room. Being aware of the risk that the beating by other corrections officers could result in the death of Robert Brooks and having the duty to intervene, you did not order the beatings to cease and delayed ordering timely medical assistance for the deceased, Robert Brooks, until it was too late to save him. Do you admit that to be true?
Yes, Your Honor.
Would you want anything further, counsel?
Judge, I discussed very briefly with Mr. Capezza. I have in my hand a form dated June 4th, 2024. What it is, Your Honor, is a acknowledgement by various corrections officers that on that date and earlier they were trained and supervised by docs on their duties, including the duty to intervene as outlined in a Directive 4944. Just want you, Mr. Capezza, if your client would acknowledge that on that form, which would have been an exhibit at his trial, that is in fact his signature from June 4th, 2024. Defendant.
Mr. Mashaw, do you acknowledge the same?
Yes, Your Honor.
Anything else?
With that, Your Honor, I'm satisfied with the allocution.
Mr. Mashaw, how then do you plead to that 4th count, manslaughter in the 2nd degree, guilty or not guilty?
Guilty, Your Honor.
You are 48 years old now?
Yes, sir.
Can you read and write the English language?
Yes, Your Honor.
Are you a citizen of the United States?
Yes, Your Honor.
Do you have any physical or mental problems that could prevent you from understanding what you're doing here today?
No, Your Honor.
Did you consume any kind of drug, medicine, or alcohol before coming to court that could affect your understanding?
No, Your Honor.
And you're not currently on probation or parole, correct?
No, Your Honor.
By pleading guilty, you're giving up your right to have a jury trial. Do you understand that?
Yes, Your Honor.
At a jury trial, you would be presumed innocent and you would be entitled to the following rights: to be represented by your attorney, to confront and cross-examine witnesses presented by the government. You'd have the right to remain silent and not incriminate yourself. You would have the right, but would not be required, to call witnesses, or you could testify on your own behalf. You would also have the right to require the government to prove your guilt beyond a reasonable doubt to a jury of 12 people who would have to be unanimous in finding you guilty. Do you understand you have each of these rights, and by pleading guilty here today, you're giving up each of these rights?
Yes, Your Honor.
Do you understand by pleading guilty, you're also giving up any defense you might have to these charges?
Yes, Your Honor.
A plea of guilty is the same as a verdict of guilty, rendered by a jury after a trial. Do you understand that?
Yes, Your Honor.
Other than the plea and sentence agreement I spoke of earlier, has anyone made any other promises to get you to plead guilty?
No, Your Honor.
Did anyone threaten you or force you to plead guilty?
No, Your Honor.
Have you entered this plea today, voluntarily and of your own choice?
Yes, Your Honor.
While you're incarcerated for this felony conviction, you will not be able to vote in an election until such time as you are released. Do you understand that?
Yes, Your Honor.
Based upon the defendant's statements and his demeanor here in court, I find in knowing voluntary plea with a factual basis. I will direct the clerk to enter the plea in the minutes of this court. We will adjourn sentence until
November 21st.
November 21st, 9:30 a.m. for sentencing. Does Mr. Mashaw wish to remain out on the bond he previously posted?
Yes, Your Honor.
The court will permit the same, Mr. Mashaw, but I'm attaching 3 conditions as part of our plea agreement. Condition 1 is you have to meet and cooperate with probation as they prepare your pre-sentence report. Condition 2, you have to come back here to court on any date you're required to be here. As of right now, November 21st, 9:30 a.m. to be sentenced. Condition 3, you must commit no new offense. There are to be no new arrests of any kind between now and the time of your sentencing. And that includes, you are not to interfere in any way with the trial of your upcoming co-defendants. I don't want you intimidating or interfering with witnesses or having contact with them of any sort. Do you understand each of those conditions?
Yes, Your Honor.
If you fail to abide by one or more of those conditions, then I would not be bound by this sentence agreement. I would not permit you to withdraw your plea, and I would then be authorized to sentence you to any term our law permits, up to and including the maximum term in state prison. Is that understood?
Yes, Your Honor.
Let me speak with probation here on your way out this morning. I'll see you back here November 21st.
Thank you, Your Honor.
Thank you.
Another one down. Another one taking that guilty. So what the rest think they gonna do going to trial when all these people taking this guilty? What they think they gonna argue? You was obviously part of it. You was obviously there. They got you on camera. What you expect to happen? You dumb man. What up, Indigo Kempra? I see you. Appreciate you joining, family. Keisha in the building, Allie in the building, Brown Sugar Babe in the building, no one in the building. Appreciate y'all, much love. Juden GA. Is it Juden Guy or Juden GA? Michelle B. Appreciate all y'all, family.
We're back on the record now in the matter of the people against Michael Fisher under indictment 25035. This matter is on for a final pretrial conference today. However, I know there have been some continuing discussions between the parties about a possible resolution. How does your client wish to proceed today, Mr. Eisman?
Your Honor, just to formalize what just occurred, the people had a formal offer this morning, a plea of 2 1/3 to 7 with no waiver of appeal, and we're formally rejecting that offer and we're ready to go forward to trial.
I hear you correctly, you said you're rejecting.
Rejecting and ready to go forward to trial.
Mr. Fisher, let me just go over that with you. What the people had proposed was that if you pled guilty to count 5, the felony offense, manslaughter in the second degree, they're recommending a sentence of 2 1/3 to 7 years in state prison, along with mandatory state surcharges. As I understand it, they would not be requiring a waiver of appeal in this particular instance, such that you would be able to challenge the validity of that conviction before a higher.
And that's crazy to hear him say it would not be, you would not have to waive your appeal rights, because remember how all the charges that Miss Love and them was reading against the YSL gang, everyone was saying you have to you have to give up your right to appeal. Like, why would you make somebody give up their right to appeal to take a plea? That's stupid. But that's well, I guess not. I guess if you snitching on somebody, then it's like they don't want you to take it back later.
Higher court. If you're convicted after trial of this same offense, you face as much as 5 to 15 years in state prison. Understanding your exposure, we will not see an offer this favorable again as we go forward. You want to reject that offer today?
Yes, sir.
I like the offer then as rejected. I have received the people's witness list. You have a witness list you can supply to the court and prosecution, Mr. Eisman?
Your Honor, at this time we don't have any intention of calling witnesses. If that changes, I will properly inform the prosecution as well as the court.
Thank you. And Mr. Eisman, would you like the court to include the no unfavorable inference charge about the possibility of your client not testifying?
Yes, Your Honor.
The court will do so. Have you discussed an anti-Markey waiver with your client?
I have, Your Honor. He wishes a waiver.
I'll pass that over. Mr. Fisher, you probably heard me talk about this with one of the prior co-defendants. The first order of business is selecting your jury. 2 weeks from today, that involves questioning of the jurors. The majority of that will take place in your presence, but should there be any sidebars, you have the right to be present for those or remain seated at counsel's table. If you're going to remain seated and not participate in those, there's a writing you must sign to that effect.
Ain't no more Rico left. Benny used it all up. She wore out.
My understanding then, Mr. Fisher, is you're going to remain seated and not participate in any sidebars during voir dire. Is that correct? Yes, sir. I received a writing now entitled Waiver of Right to be Present During Sidebar Conference that appears to bear the signature Michael Fisher. I'm holding that up for you now. Did you in fact sign this document after reviewing it with your attorney? In signing and approving the waiver as well. I'll remind the attorneys if there are any unusual questions of law or requests to charge, sooner than later will be to your advantage. The court also does prefer exhibits marked in advance to the extent possible. I'll remind the attorneys that during jury selection, avoid discussing the law, do not be repetitious, do not make improper appeals to bias, sympathy, or prejudice. There will be a 20-minute limit per panel for the prosecution and initially for the defense, but with as many defendants as I expect, the court will use its discretion to significantly curtail any successive questioning by defense counsel should it become repetitive. I've passed out an outline of the court's intentions with respect to press access to proceedings. Are there any objections to that by the prosecution?
No, Your Honor.
Objections to that, Mr. Eisman?
I object to a live feed, Your Honor.
All right.
Wait a minute, wait. I know he did not just say what I think he did. Let me run that back 2 seconds. Did he say he object to a live feed? Nah, bro. We running all this whole trial. We running that. What you doing?
Your Honor.
No, Your Honor.
Objections to that, Mr. Eisman?
I object to a live feed, Your Honor.
All right.
Just noting for the record.
Just noting your objection for the record. All right, duly noted. The court's considered the balancing of competing interests here and nevertheless will permit the same. Is there anything further than from the prosecution?
Judge, I was waiting until after today to mark our exhibits. We've got them all prepared, and I will get to the court and counsel this week a list of the exhibits and what witnesses we will be calling to get those exhibits in. If there's any stipulations from the defense regarding the videos, if they could let me know so we don't have to fly people in from Arizona, from Axon. They don't stipulate to that, that's fine, I understand.
Okay, very good. I'll leave you to have those discussions. There might be some foundational testimony that could be avoided as unnecessary. Did you have anything else, Mr. Fitzpatrick?
No, Your Honor.
Did you have anything else, Mr. Eisman?
A couple of matters, Your Honor.
Right ahead.
The first is in response to this court's decision and order on our omnibus motion. The court had directed the people to follow up on the demand for a bill of particulars, and specifically to address whether they were proceeding on a principal or accessory theory of liability, and otherwise comply with 2095 of the CPL. I followed up with the people. They are committed to just an accessory theory of liability. So I wanted to, that was just an email correspondence. There wasn't any formal filing to that effect. So I just wanted to confirm that that was the case. For the record, that's my understanding. And that's how we're proceeding here and moving forward. And assuming that is the case.
Hold on. Sure. Let's cement that in. Is that in fact your position then going forward?
It's not my position, Judge. I apologize if we've said that in writing before, but this is a crime, as we've outlined, in terms of satisfying a bill of particulars that I think we've outlined in great detail in the indictment itself. It's a crime of omission. It's not an accomplice to failure to report or failure to act. That's what he did not do. That is our theory of prosecution. That's not going to be any surprise to Mr. Eisman or anyone else at trial.
It is in the sense that now we've got somewhat confusing or completed assertions. So I'd ask you if you could simply respond in writing in a bill of particulars and lay that out exactly what your theory is. The defense is very clear as we move forward.
Get that out to you today.
Thank you.
And counsel.
You said you had some more, Mr. Eisman.
Well, I guess part of my more will depend on what theory of prosecution I'm moving forward on, Your Honor. And so I may have a filing to the court depending on what theory they're actually proceeding on at that time. The second issue is I would like to leave to review my motion to sever Mr. Fisher's case from the remaining defendants. I know that at least Mr. Kingsley will be going to trial based on today's proceedings. It sounds like 2 other co-defendants are contemplating offers. I don't know what their status is going to be. But I would, no matter who remains standing at the end of today and going to trial, I am renewing my motion for a severance, and I can more fully articulate those reasons in writing to the court, but I think that I know that there will be antagonistic defenses between at least myself and Mr. Kingsley's counsel throughout this case, and with the remaining defendants who are standing. And I don't think this should come as a surprise to anybody about the nature of the antagonistic defenses. And so I'd like to renew that motion to sever, and can you proceed in writing to the court or make it now if the court's prepared to rule on that issue at this point?
What I would suggest is this. If you've got something new and different that you want me to consider apart from your original filed motion, I'll give you an opportunity to submit me something, but we're running out of time, so that's going to have to come, say, by the end of the week.
I'll file something by the end of the week, Your Honor.
By the end of the week, I'll then calendar the matter for Wednesday of next week, October 1st, to address that outstanding issue.
For appearance here, Your Honor?
Yes, a board appearance. And in between now and then, you should have received a people's supplemental.
Hey, who been around long enough, real quick, to remember when we used to have the emojis walking out when you hit the chat prompts and then they walk out and try to race to the end? I'm gonna bring that back. Something like it, maybe a little different, but I'm gonna bring that back. Who been around that long?
Bill in particular, so if you have any issues with that, that would be the time to take that up as well.
Okay. Thank you, Your Honor.
Do you have anything else, Mr. Axel?
Last issue, Your Honor, is I'm going to be requesting early disclosure of jury questionnaires in this matter. Due to the high-profile nature of the case, potentially the number of co-defendants, I'm expecting that jury selection will be a lengthy process. And in my past experience, it's helped significantly with early disclosure of jury questionnaires with a protective order for attorneys' eyes only, so that we can at least weed out the blatant, obvious for-cause challenges and other people to help speed up and expedite the jury selection process. So I can again make that a more formal application. I want to give the court a heads up that that's something I'll be requesting.
Mr. Fitzpatrick, do you take a position with respect to that request?
I leave the conduct of the trial to Your Honor.
All right, Mr. Eisen, that one's a bit easier. This court is not empowered with the authority to supply you with the relief you're requesting in the form of the early release of those lists of prospective jurors. Even if I was, I would deny that request. Nothing good can come from that imbalance. And there's the potential for far more harm than good. So that request is denied. Did you have something else?
No, Your Honor, that's it. I wait to finalize bill particulars, and I'll follow up with the motion this over.
In that case, I'll see you all back here on October 1st. The trial will begin October 6th, 9:30 a.m.
October 1st at 9:30 also?
Yes.
Okay, thank you.
So another one going to trial. And for those who didn't catch it, they saying that it's going to be a pre-hearing on the 1st, October 1st, and then the actual trial is going to start on October 6th. This attorney is going to be one to watch. Yeah, that's a fact. That's good that he going to trial. We're going to want to see that one and watch them all lose. But I don't know. I guess it depends on the case. It depends on the evidence. I ain't going to say they just going to lose, but we know they was all there, and we know they was all part of it, and it should be a RICO. We know that. We know that much.
Tell everybody, well, I still fight through the devil, man. Johnny bitch over there, y'all got to do what they want, bro. I mean, people want to do it, ain't time for it.
Nicholas Kiefer.
Good morning, Your Honor.
Good morning. Counsel, approach for a moment, please.
The absence of evidence is not the evidence of absence.
What?
The matter of people against Nicholas Kiefer under indictment 25035. This matter is on for a final pretrial conference. My understanding is before I get to the final pretrial conference matters, that a somewhat revised offer had been extended. The proposal would be that the defendant would plead guilty to one count of felony offense of gang assault in the second degree. The agreed upon sentence would then be 9 years in state prison with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges. What is your client's position with respect to that, Mr. Longrow?
Your Honor, that was the last offer that was extended. I reviewed that with my client together with the potential downside of going forward. My client has rejected that offer, Your Honor.
Mr. Kiefer, let me just go over this with you to make sure you understand, sir. You discussed with your attorney the evidence that the prosecution has against you, correct?
Yes, sir.
You understand that what the prosecution has offered is, in fact, a lesser charge than the highest charge against you in the indictment?
Yes, sir.
They're proposing that you plead guilty to gang assault in the second degree with a 9-year sentence. If you were convicted just of that charge, you're facing 15 years in state prison. But you also have a much higher charge. You're charged with murder in the second degree here, for which the law would permit me no alternative but to sentence you to life in prison if you're convicted after trial of that offense. Understanding your exposure is life, you want to turn down the offer of 9 today?
Yes, sir.
That's in full consultation with your attorney, and you know what you're doing.
Yes, sir.
Mark the offer then as rejected. We'll move forward with the final pretrial conference. I received the prosecution's witness list. Did you have a witness list for me, Mr. Longrow?
I do not have a witness list prepared, Judge. I will get one out by the end of the week. We do know that we'll be calling Dr. James Terzin, and I'll have to talk to Mr. Fitzpatrick more about the actual timing of that because of my actual witnesses' conflicts here throughout the month of October. I'm looking at early November, probably getting testified, assuming the trial goes well in 4 weeks.
Did you say November?
We're planning on a four-week trial, is that correct, John?
Worst possible case scenario. The prosecution had estimated for me about 3 weeks.
Oh, I thought you said 4.
Everyone to keep their calendar clear for 4, just in case something ran over long, but I don't expect to be hearing testimony in November.
Okay, very good. Then I will work with my expertise.
Adjust as needed.
Understood, Judge. Will do. Your Honor, also on today's date,
The absence of evidence is not the evidence of absence.
What?
Real quick. Shout out to Allie, dropping another gifted membership. Y'all show her some love. Appreciate the support, family. Drop her some what up, send some coins in the chat. But hey, check this out. Allie said, hold on, where it go? It's moving. All right. She said, let me see if I can find and grab Rico that's missing from this case while I'm getting Play-Doh. Look, the only way we gonna ever see Rico these days, I think you gonna have to go ahead and make one out of Play-Doh. You and your kids on your Play-Doh date gonna have to form up and make up a Rico. That's about the only time we gonna see one. Y'all show Ali some love. Appreciate you, family. Stream sponsor.
I filed, not to interrupt, Your Honor, another motion in limine. I filed one, I think, last week with respect to some prior disciplinary / use of force matters. I believe the court had that, and this morning I filed one with respect to asking the court to take judicial notice with respect to no penal law statute on the books for the remand judge.
I'll get to that in just a minute.
Oh, I'm sorry, Your Honor. I apologize.
Mr. Longrow, would you like the court to include the no unfavorable inference charge regarding the possibility of your client not testifying?
Correct, Judge, yes.
The court will do so. Instruct your client regarding an anti-barky waiver.
Yes, Judge. And he will waive.
I'll pass that over, Rick, if you would. Mr. Kiefer, the first order of business 2 weeks from today is selecting your jury. During the course of that questioning will occur. You have a right to be present for that questioning. If any of that questioning occurs during the sidebar or outside your presence, and you want to remain away from that, you'll have to sign a writing to that effect. It's my understanding after conferring with counsel that is your wish.
Yes, sir.
All right. The court is accepting the same, and I received the written waiver of right to be present during the sidebar conference that appears to be a signature, Nicholas Kiefer. I'm holding up that for you now, and confirm for me, sir, you executed this document after reviewing it with your attorney.
Yes, sir.
Is signing and approving the waiver as well. If there are any unusual questions of law or requests to charge, remind the attorneys it's to your advantage to advise the court of that sooner than later. The court does prefer exhibits marked in advance to the extent possible. Counsel is reminded that during jury selection, you are not to discuss the law, do not be repetitious, do not make improper appeals to bias, sympathy, or prejudice. There will be a 20-minute limit per panel for the prosecution and initially for the defense. But with the several co-defendants, the court will use its discretion to significantly curtail successive questioning by defense counsel should it become repetitive. I've also supplied the attorneys with a copy of the court's order with respect to coverage of the proceedings. Are there any objection from the people?
No, Your Honor.
Any objection of the defense?
No, Your Honor.
The court will permit the same. Is there anything further from the prosecution?
Judge, I thought this was a request regarding his prior disciplinary record.
There was that filed, and he's apparently filed a second new motion in the this morning.
Okay. This one I can address now or later if you want it writing.
When you say this one, are you talking about the one filed this morning?
The one you just handed me.
Go right ahead.
He's essentially requesting that you charge the jury that there is no penal law statute regarding the duty to intervene. I would disagree with that. There is a penal law statute regarding the duty to intervene. It's called manslaughter in the second degree. And I would ask that you charge the jury consistent with your prior rulings in this case.
All right. How about with respect to the other motion? Do you have any thoughts on that?
We have no intention of offering on our direct case the disciplinary history of any of the defendants. We do, of course, reserve the right, should they testify, to cross-examine them about that, or should they offer any character witnesses as evidence during the trial.
Understood. Mr. Long?
Thank you, Your Honor. Yes, I do.
All right. So then with respect to the defendant's disciplinary records, the court will not permit the prosecution to enter that as part of their affirmative case, but you understand, Mr. Longaretta, there does remain a possibility, depending on the proof or testimony of your client, you could open the door to that jury.
Understood, Your Honor.
And then, did you want to be heard in support of your other motion in limine?
Yes, Judge. I think.
Before he get to his other motion, let's get a refresher of what this case is about. And so he's going to be taking it to trial. That's another one. But let's just tap in real quick for those who just joining us. Appreciate y'all being here. Don't forget to hit that like button.
Oneida County was caught on body-worn cameras and prompted calls for justice. 13 WAM's Natalie Calzatoni sat down with Robert Brooks Jr. today and joins us now with the latest developments in this case. Natalie.
Karen, I caught up with Robert Brooks Jr., who has been busy meeting with reform groups and lawmakers to try and enact change in the prison system, and he says he won't feel okay until his father gets justice. 4 months ago, an incarcerated man from Rochester died following a beating by corrections officers caught on body-worn cameras. Robert Brooks's family left to navigate the unthinkable.
We've been hurt, we've been heartbroken, but we also are finding the silver lining into this situation because now we have a voice and we want to use our voice to help millions and everybody else out there in the future.
Robert Brooks Jr. and his family filed a civil lawsuit in January against 17 individuals, including Docs Commissioner Daniel Marticello. A motion was filed by the state attorney general last week to have claims made against Marticello dismissed because of failure to allege his personal involvement in the violation of Brooks's constitutional rights.
It's not surprising just because we've been in these meetings, we've been sitting down with people, and it's like no one wants to take accountability.
Last month, a similar incident reported right across the street from Marcy Correctional Facility at Mid-State Prison.
I was furious. When it first happened, I was furious. I didn't know what to think.
Per the indictment, 10 corrections officers are charged in connection with the fatal beating of 22-year-old Messiah Nantwi.
My first initial thought was, I pray that they got it on camera. I pray that they got it on camera or some type of body footage where they don't try to make Messiah, or let's not speak just about Messiah, but my father, that they wouldn't try to blame the defendant.
The COs in Nantwi's case all pleaded not guilty to the charges last week. Meanwhile, 5 out of the 10 former Marcy correctional officers accused in Brooks's death are considering plea deals.
Yep, right across the street, because it's 2 prisons across the street from each other. They killed somebody right across the street. And then I think one of them, I forgot which one happened first, but I think the second one was in response because they was mad at the first one. And they was mad because the people was getting in trouble. So they said, what? We gonna do it too. Crazy stuff. Groupthink is a fact. That's a fact. Appreciate y'all, family. Let's keep it rolling.
I think I laid it all in my papers, the one that I filed today, perusing the criminal procedure laws, the penal law. There is no statute on point. I understand Mr. Fitzpatrick's argument. I disagree with that.
All right, your disagreement and your objection for the record is noted. However, your motion to eliminate will be denied. Did you have anything else, Mr. Fitzpatrick?
No, Your Honor.
Anything else, Mr. Longaretto?
I believe that's it. Just one quick question, Judge. Is it possible, and I don't know if the court has time today, for just a logistic meeting as to where we're going to do the trial, how we're going to set it up?
I don't have the ability to do that for you today, Mr. Longaretto, but if need be, we could have an informal get-together so we can discuss that.
Okay, thank you very much, Your Honor. That's all I have for today.
All right, I'll see y'all back here then, October 6th, 9:30 a.m. to begin jury selection.
Thank you, Your Honor.
Another one for trial. There go another one for trial. I think we're almost about even. Did we do all 4? All right, I think it's only 1 or 2 more to go. But that's crazy though. And like I said, the same thing happened right across the street from the same jail. Still no RICOs, none of that. Y'all killing people in prison. And knowing this ain't the first time it happened, y'all just now getting in trouble or, you know, being held accountable, but they've been doing this all across America. Everybody say, oh no, it's just you guys. You're just such bad people. You're just such a bad person. You deserve everything you get, right? And then they don't prove nothing. And then they come in here with the proof and they let these people just walk out. Just walk all around like nothing never happened. Where they do that at?
We're back on the record in the matter of the people against Matthew Gallagher under Amendment 25-035.
Gallagher back.
This matter is on for a final pretrial conference today. I know there have been some continuing discussions between the parties. How does your client wish to proceed today?
We're prepared to proceed, Your Honor, without accepting the plea offer.
Let me just go over that and make sure you understand, Mr. Gallagher. What the people had proposed is that if you pled guilty to 1 count of the felony offense of gang assault in the 2nd degree, they're recommending a sentence of 10 years in state prison, along with 5 years post-release supervision, a waiver of appeal, and mandatory state surcharges. If you're convicted after trial, you are charged with a higher offense, murder in the 2nd degree, for which the law requires a sentence of life be imposed. Understanding your exposure, that you will not see an offer this favorable again now as we go forward. You want to reject that offer of 10 years? Mark that offer then as rejected. Proceed with the final pretrial. And receive the prosecution witness list. Did you have a witness list for me, Mr. Lugar?
Or any witnesses we would have would come from the prosecution's witness list. That changes all informed the court.
Mr. Lugar, would you like the court to include the no unfavorable inference charge about the possibility of your client not testifying during voir dire?
Yes, Your Honor.
The court will do so. Have you discussed an anti-marking waiver with your client?
Yes, I have, Your Honor.
How does he wish to proceed with
He wishes to execute the waiver.
All right, I'll pass that over for you. Gallagher, the first order of business in 2 weeks is to select your jury. During the course of that, questions will be asked of the jurors. You have a right to be present during all of that questioning. However, if any of that occurs during the sidebar conference or outside your presence, you would have to consent and agree to that in writing. If you wish to do so, there's a writing to that effect that's been supplied to your attorney. I'll give you a moment to discuss that with him now.
Your Honor, I'm handing out up the fully executed waiver of right to be present during sidebar conferences.
Thank you. And Mr. Gallagher, am I correct, sir? You're then agreeing to remain seated and not partake should there be any sidebars or discussions outside your presence during voir dire? Yes. All right. received a writing to that effect. It's entitled Waiver of Right to be Present During Sidebar Conference, which appears to bear the signature Matthew Gallagher. I'm holding that up for you now. You can confirm for me you signed this after reviewing it with your attorney.
Yes.
Court accepts and is signing and approving the waiver of right to be present during sidebar conference. I remind the attorneys if there are any unusual questions of law or requests to charge, it is to your advantage to advise the court of that sooner than later. The court does prefer exhibits marked in advance to the extent possible. During jury selection, avoid discussing the law. Do not be repetitious. Do not make improper appeals to bias, sympathy, or prejudice. There will be a 20-minute limit per panel for the prosecution and initially for the defense. As I noted, some of the prior co-defendants, the court will use its discretion to significantly curtail successive questioning by defense counsel should it become repetitive. Also, I've outlined.
So real quick, Trakisha said, the source, FOTG, I have a friend who is in internal affairs for New Jersey prison systems. The stories I hear, some of them people are devils. They're murder inmates all the time out there. Broken heart, that's a fact. And Ali said, how you going to go to trial and think you're not going to be found guilty when it's all on body cam? Facts. And so after this run too, I got the other person who has been found guilty. He was sentenced to 15 years, so we'll play that one next. And it's still part of the same case, but he pled guilty about a month ago.
I've supplied an outline of the court's intentions with respect to press access to the proceedings. You have continued to have no objections, Mr. Fitzpatrick?
Yes, Your Honor.
Do you have any objection to that, Mr. Newberry?
No, Your Honor.
All right, the court will be permitting the same then. Is there anything further then from the prosecution?
There is not.
Anything further from you, Mr. Newberry?
Yes, Your Honor, several things. Your Honor, I filed this morning with the clerk's office a motion in limine. I made a copy of the defense counsel, and I have copies for all counsel.
Yeah, so Mr. Lubrand, I'll acknowledge that I received that. However, considering the volume of what you've supplied me here with, I'm not in a position to review that as it's probably necessary to do so. I imagine Mr. Fitzpatrick's going to have the time this morning to get through that and respond intelligently. What I would suggest then is if the prosecution has any written response to that, to supply it by the end of the week, and I can have you back then for any argument you wish to make on October 1st of next week.
Is that a set date, Your Honor, or is that if there's opposition? I'm not sure if I just want to make sure whether October 1st at 9:30 is when you expect me next.
October 1st would be when I expect you next. I'll hear you out on any arguments you have in support of it, and I'll issue a decision at that time.
Thank you, Your Honor. I've also asked a copy of the bill of particulars that's going to be served as relates to Mr. Fisher's case. Request that the prosecutor provide me a copy as well.
Well, we'll provide copies to all counsel remaining. Judge, may I address this motion in limine?
You may, if you like.
On number one, request, will respond to that in writing. Number two, preclusion of testimony at trial which narrates video evidence. I'm not sure what I'm supposed to do during the trial, just hit the play button and call the medical examiner and sit down, or perhaps have a witness explain to the jury who's doing what, who's Mr. Brooks, et cetera, et cetera. So I would strongly object to that. Number three, preclusion of documents and testimony regarding the duty to intervene. Preclusion of documents and testimony regarding a duty to intervene. That's the whole thrust of the case regarding the defendants charged with manslaughter. I'm not sure how it affects Mr. Gallagher, as he's charged with depraved mind murder and intentional manslaughter. As to number four, preclusion of non-testifying co-defendant statements which criminally implicate Mr. Gallagher. We have no intention of violating the Bruton rule or causing any severance issues, so that's, in my judgment, not an issue. So we'll address number one and perhaps 2, 3, and 4 further in writing, but those are my positions off the top of my head.
All right, duly noted. I would ask that you supply that writing by the end of the week, Friday, September 26th. And again, I would then hear the parties out on October 1st and render a decision at that time, so you have sufficient advance notice before we head forward to trial. Do you have something else, Mr. Blueberry?
Yes, Your Honor, I just do want to respond briefly, and I know we'll have another opportunity to do that at oral argument, but to the extent before people's positions become formed, I'm not asking Mr. Fitzgerald's team to just play the video and sit down. They can identify who is who and where things are. But the second they say that so-and-so is beating Mr. Brooks, that's a narration. That's not permitted. That's the jury's province. It's hearsay, it's inadmissible, and it's a grounds for mistrial. I will make a grounds for motion for mistrial the second that they try to narrate. We made that application in connection with our the grand jury, because that was done at the grand jury, and we're going to make the same application here. We'll preserve our rights here. With respect to the special prosecutor's statement that the charge is manslaughter, well, that's well and good. But if they believe that the manslaughter statute is sufficient to support the allegations, then there's the DOC's directive is an inadmissible document. That's not the state of the law. That's the state of DOC's employers' requirements for its employees. It is not the state of the law. The manslaughter statute is the state of the law. And Mr. Fitzpatrick just said before my case with Mr. Fisher's case that it's the manslaughter statute that is the law, and that is the law, Your Honor, and that's the law that should be read to the jury, and that's what should be allowed in this case, and not any extraneous DOC's directives or memos from any DOC's people. You'll probably hear the same argument October 1st, Your Honor.
And that's why I reserved that date. So hold your thoughts on that until the 1st. I'll take the people's written submission, and I'll hear you out further to the extent necessary on that and any of the other issues that you've raised by way of your motion. Do you have anything else, Mr. Woodring?
No, Your Honor.
Anything else, Mr. Fitzpatrick?
No, Your Honor.
All right, I'll see everyone back here then October 1st. The people will supply their written response to the motion and eliminate by September 26th. October 1st, 9:30 a.m. Yes, Your Honor.
Take that shit to motherfucking trial, yeah. He said he's taking it to trial. That's another one.
You can take that dog. No, he's sleeping. Take that dog.
Said he taking that shit to trial. Yeah. I think that's, is that it or is one more? I think it's one more. Oh yeah, one more. We gotta bring Santa back. Santa gotta come back because he didn't finish earlier. And then we'll get to the sentencing of their co-defendant who already pled guilty and got 15 years, family. 15 years for murder.
Recall David Walters.
This is the matter of people against David Walters, indictment 25035. This matter is on for a final pretrial conference this morning. However, it's the court's understanding that a somewhat revised proposed disposition had been extended. How does your client wish to proceed with respect to that, Mr. Passalacqua?
After lengthy discussion with myself and his family, it's my understanding that Mr. Walters wishes to proceed forward in accepting the people's amended offer as presented this morning.
Let me state my complete understanding of what's been proposed. That would be a plea of guilty to count 6, that is a felony offense of manslaughter in the second degree. The agreed upon sentence would then be 2 1/3 to 7 years in state prison, along with mandatory state surcharges. However, neither the court nor the prosecution will be requiring a waiver of appeal in this instance. Is that people's understanding?
It is, Your Honor.
Mr. Passalacqua, that's your understanding?
It is.
Mr. Walters, is that your understanding of the proposal to resolve these charges, and is that what you want to do here today? Please raise your right hand. You now swear you will tell the truth, the whole truth, nothing but the truth, so help you God. You may put your hand down. Mr. Walters, I'm going to ask you some questions now. So to help you decide if I can accept your plea. At any time you do not hear a question, you do not understand, or you need a moment to stop and speak further with your attorney, you have to let me know that, okay?
Truth is, you are a liar.
You're pleading guilty here this morning. You're giving up your right to remain silent and to not incriminate yourself. Have you spoken with your attorney about your case, about pleading guilty and thereby waiving your right to have a trial?
Yes, sir.
Are you satisfied with the services of your attorney?
Yes, sir.
Have you had enough time to speak with your attorney about your case?
Yes, sir.
The charge you are to plead guilty to pursuant to this agreement is count 6, charging you with the felony offense of manslaughter in the second degree in violation of Penal Law Section 125.15, Subdivision 1, and 20.00. It is alleged here that on or about December 9, 2024, in the town of Marcy, County of Oneida, you did recklessly cause the death of Robert Brooks. Specifically, you were present in the infirmary and in the emergency room and had a clear opportunity to witness the beating of Robert Brooks and was aware of the risk that the beating by other corrections officers could result in the death of Robert Brooks. Having a duty to intervene, you did not in any way attempt to stop the beating and did not in any way attempt to shield Robert Brooks from the onslaught. In addition, while an infirmary nurse attempted to enter the emergency room to attend to Mr. Brooks, you verbally instructed the nurse not to enter the emergency room.
Sound like Rico to me.
Is that true?
Yes, sir.
Do you want anything further, Mr. Fitzpatrick?
Just as I did with Mr. Mashaw, Mr. Vasilako, I'm going to hand you a form dated July 29, 2024, and what it is a DOC's training acknowledgement form regarding various weapons that they are entitled to use, as well as use of force, which
Miss D56, what up? You see, why is this not Rico? You hear what he just said that this dude did?
includes a duty to intervene. And if you just would have your client acknowledge that's his signature on that form. That's it.
You've reviewed that with your client's testimony?
Yes, sir.
And you acknowledge the same, Mr. Walters?
Yes, sir.
All right. Anything else, Mr. Fitzpatrick?
No, Your Honor, people are satisfied by the allegation.
Mr. Walters, how then do you plead to that 6th count manslaughter in the second degree, guilty or not guilty?
Guilty.
You are 37 years old?
Yes, sir.
Can you read and write the English language?
Yes.
Are you a citizen of the United States?
Yes.
Do you have any physical or mental problems that could prevent you from understanding what you're doing here today?
No, sir.
Did you consume any kind of drug, medicine, or alcohol before coming to court that could affect your understanding?
No, sir.
You're not currently on probation or parole, correct? By pleading guilty, you're giving up your right to have a jury trial. Do you understand that?
Yes.
At a jury trial, you would be presumed innocent and you would be entitled to the following rights: to be represented by your attorney, to confront and cross-examine witnesses presented by the government. You'd have the right to remain silent and not incriminate yourself. You would have the right, but would not be required, to call witnesses, or you could testify on your own behalf. You would also have the right to require the government to prove your guilt beyond a reasonable doubt. To a jury of 12 people, you'd have to be unanimous in finding you guilty. You understand you have each of these rights, and by pleading guilty here today, you're giving up each of these rights. You understand by pleading guilty, you're also giving up any defense you might have to these charges. Now, a plea of guilty is the same as a verdict of guilty rendered by a jury after a trial. Do you understand that?
Yes.
Other than the plea and sentence agreement I spoke of earlier, has anyone made any other promises to get you to plead guilty?
Yes.
Did anyone threaten you or force you to plead guilty?
No, sir.
Have you entered this plea today voluntarily and of your own choice?
Yes.
You understand while you're incarcerated for this felony conviction, you will not be able to vote in an election until such time as you are released. Based upon the defendant's statements and his demeanor here in court, I find a knowing voluntary plea with a factual basis. I will direct the clerk to enter the plea into the minutes of this court. We will adjourn the sentence until
November 21st.
November 21st, 9:30 a.m. for sentencing. Does Mr. Walters wish to remain out pending sentence?
Yes, please, Your Honor.
All right, Mr. Walters, I'll permit that based on the bond that you previously posted with the court. However, I'm intentioning 3 conditions as part of our plea agreement. Condition 1 is you have to meet and cooperate with probation as they prepare your pre-sentence report. Condition 2, you have to come back to the court on any date you are required to be here. As of right now, November 21st, 9:30 a.m. for sentencing. Condition 3, you must commit no new offense. There are to be no new arrests of any kind between now and the time of your sentencing. And part of that is you are not to interfere with any of the witnesses in the ongoing case against your co-defendants in this case. You have no contact with any of those witnesses. You understand each of those conditions?
Yes, sir.
If you fail to abide by one or more of those conditions, then I would not be bound by the sentence agreement. I would not permit you to withdraw your plea, and I would be authorized to sentence you to any term our law permits up to and including the maximum term in state prison. Is that understood?
Yes.
Speak with probation on your way out this morning. I'll see you back here November 21st at 9:30 a.m.
Thank you, Your Honor.
Julian said 100% Rico. No one said, and they call us criminals. Fuck out of here. That's a fact. That's a fact, man. They crazy, yo.
The absence of evidence is not the evidence of absence.
What?
Shout out to our stream sponsors so far. Y'all show them love. Shout out to Ali and Chandmar Black is Golden. Much love, much love. So we gonna keep on rolling to the next one. That's crazy though, man. That's crazy. That's crazy. That's definitely Rico. He said he said that he was right there. He seen it happen. He watched it happen. He knew it in two different places that it could risk him dying. And then he told the nurse not to do her job. Crazy. That's definitely Rico, family. That's definitely Rico. All right, let's keep it on rolling. So this is the one that's part of their Rico gang that already admitted guilty and got 15 years, which like he'd probably be out in 7.
Christopher Waller. Counsel, I do have a request from numerous media outlets to cover those proceedings and objection from either side.
No objection. No, Your Honor.
Or will permit the same. This is a matter of the people against Christopher Wallraff and Dr. 25-035. This matter is on for sentencing today. It's back on May 5th. The defendant pled guilty to 1 count of manslaughter in the first degree. With the agreed upon sentence being 15 years in state prison along with 5 years post-release supervision of waiver of appeal and surcharge. Is that people's understanding?
It is, Your Honor.
Including executive.
Well, isn't this a nice surprise?
15 years on that ass. 15 years. Like I said, he'd probably be out in 10, 8 or 10, maybe 7 if he lucky.
Yes, it is.
You want your sentence?
We do.
Would you like to hear?
I would. Judge, I'll be brief as this is an agreed upon sentence, but nevertheless, some comments need to be made. On December the 9th of 2024, incarcerated individual Robert Brooks was transferred to the custody of corrections officers at the Marcy Correctional Facility, and they took custody of him at approximately 9:07 p.m. that evening. At approximately 9:40 that evening, he was clinically dead, having suffered massive brain trauma from multiple beatings, as well as choking on his own blood. Having been assigned as special prosecutor judge, and you as a former homicide prosecutor understand the mentality, I wanted to get to the why. What did Robert do to provoke this? Not that it was could possibly be in any way justified by a provocation, but there had to be a reason. He had to have resisted. He had to have been assaulted. Maybe he spit at one of the officers. And 8 months later, and hundreds of investigative hours later, I can answer that question as to what Robert Brooks did to provoke his death. Absolutely nothing. This was a simple welcome to Marcy. Many of us, justifiably, I still think, place trust in our institutions. People who enter this courtroom trust that justice will be dispensed and served. We drop our kids off at school. We trust that they will be educated. And on occasion, we lock people up. And we have certain trusts. We only lock people up for 4 reasons. Number one, we want to incapacitate them. We want to separate them from society so they can't continue to do what they were doing. And secondly, we want to deter future conduct. We want to send a message that this conduct will not be tolerated, and you should not follow that conduct. Thirdly, there's retribution for the victims involved. And finally, but certainly not the least, we want to rehabilitate the defendant. We want to educate the defendant. Does he have a drug problem? Does he have an alcohol problem? Does he have a mental health issue? And we trust that the person will come out better than when they entered the facility. Robert Brooks came out in a casket. I've watched that tape, Judge, that was released to the public. I'm prosecutor for 45 years. I have difficulty watching that tape. I really do. A helpless, shackled man being beaten, and a beating that this defendant actively and willingly participated in. I often wonder, had those tapes not been in existence, how much larger the fabrications would have been, how much wilder the stories would have been. I mean, this defendant even told hospital personnel who were trying to save Robert's life that he fell and hit his head. How serendipitous it was that those tapes had been discovered to bring us the truth of what happened. I remember interviewing a cooperating witness in this case early on about the falsity of the reports and the lies that were told. And I asked him, I said, when did you all get together to agree and conspire to falsify your reports? And he looked at me with a puzzled look on his face, and he said, agree? Now, we didn't need to agree. That's just what we do. And that told me all I needed to know about this case. To personalize this tragedy.
Man, my bad about the static. They was horrible with this one, huh? It's almost over though, family.
Your Honor, I have the privilege of presenting to you for this victim impact statement. One of the sons of Robert Brooks, who has been denied the opportunity to reunite with his dad, ironically would have been just over a year from now when his dad would have been a free man. So please, with your permission, Your Honor, I'd like to introduce Robert Brooks, really to speak to the court on something.
Son, Robert Brooks Jr.
Good morning. This is Robert Brooks Jr., correct?
Yes. My name is Robert Brooks Jr. Last December, I watched as you, Mr. Warlack, and the fellow correctional officer beat my father. Robert Brooks to death row camera. I'm here to give an impact statement as though I can ever truly describe to you the impact your actions have had on me and my family. You took my father, you took my son's grandfather, you took my grandparents' son, you took my uncle's brother, and the list goes on. It never occurred to you that my father was human, with a family who loved him? In that video, I see you and your fellow officers treating him as if life holds no value at all, as if you were entitled to brutalize him for sport. I want you to imagine for a moment what it feels like to see someone you love treated that way. I want you to imagine watching someone beating your own father helpless, restrained, bloody. I want you to imagine watching your own father be hit with the 50 bullet or being dragged by his neck. I want you to imagine watching all of this happen to your own father and you being total powerless to stop it. I will never get these images out of my head. They invade my consciousness without warning, flooding me with the worst feelings imaginable. They won't haunt my nightmares for the rest of my life. I am not okay, and I never will be. My father had struggles in his life, but was using his prison time to work on himself. He studied American Sign Language, deepened his faith with God, and maintained a healthy relationship with me and the family. He was scheduled to be released July 23, 2026, and he was hopeful for his future. And his family was eagerly waiting his homecoming. You took that away from us. Although I can never forgive you, I respect that you admitted what you did and accepted responsibility. And I hope that others have the courage to do the same. That goes beyond what happens in any courtroom. Anyone who watched this video can see that your actions did not occur in a vacuum. You were part of a system that dehumanized my father. Every person in authority who allows the system of violence and abuse to exist and continue must also take responsibility. Mr. Warwell, you are no longer an actor within the system. Now, your life is at the mercy of it. And I pray for your family who's going to have to spend the next 15 years worrying about you, just like all New Yorkers with depressed or their loved ones must do. No one should ever have to go through what my father and family endured. Thank you for hearing me out.
15 years is not enough.
No, Your Honor, I assume you'll cover the waiver of appeal at the end.
And where's all those people that when it happened to somebody they love, they be screaming out death penalty, kill them. Shooting firing squad. They was talking about for Charlie Kirk killer. They wanted to see the firing squad on his ass. It was I got a whole list of comments I recorded. I ain't even played that yet.
Mr. Warwell, is there anything that you want to say prior to being sentenced? I will note for the record that I did make his right to appeal at the time of this plea, so I'm not going to go those rights again. The defendant is hereby sentenced as follows. As to the conviction for manslaughter in the first degree, the defendant is hereby sentenced to a determinate sentence of 15 years in state prison, that is along with 5 years of post-release supervision. Further, there is imposed a mandatory surcharge on victim DNA fees, which will total $375. The defendant is committed to a permanent sentence.
$375. Locked him up on the spot. Why didn't let the ref? I guess he was out, so I don't know. Maybe his bail wasn't enough. He didn't pay enough bail to stay out that long. Lock his ass up. So stupid ass. Hold on. We ain't done yet. I got one more thing. 1 or 2 more before we get up out of here. Y'all don't forget to hit that like button. Keep it going. Let's keep it going.
Body cam videos were released today by Letitia James in the death of Robert Brooks at the Marcy Correctional Facility. And Hochul has issued a statement as well. It says 14 people will be fired over this. So this is an ongoing investigation into the death of Robert Brooks. He died December the 10th of this year after an encounter with New York State Department of Corrections and Community Supervision officers. This was at Marcy Correctional Facility in Marcy, New York. That's in Oneida County. Now, the day before, on December the 9th, Brooks was transferred from Mohawk Correctional Facility to Marcy Correctional Facility. Those are both in the same county, Oneida County, according to James. Brooks, she says, who was handcuffed with his hands behind his back, was then taken into a medical examination room where the events captured in the video took place here. So remember, we want to bring you some of this body camera video. Viewer discretion is advised. Let's take some of that. All right, so this was just released today by the office of New York Attorney General Tish James here. And so what you're watching right now is the moment in the wake of the transfer of Brooks from one facility to another here. So according to James, when he was transferred to this medical examination room, you're going to see it in just a moment, realized hours of December, and there is Brooks there after being transferred from one facility to another. You are going to see the actions, and it's very difficult to watch. It's graphic.
Yeah, it's so graphic. I'm not even going to play all that part because they're going to be trying to restrict my channel for that. We played it before, but we got some more. Hold on. We got something else.
Well, announcement today by New York State Attorney General Letitia James.
Good afternoon.
and she in trouble right now, evading fraud and all types of stuff. She got charges. She fighting against herself, messing with Trump.
Today, my office is releasing video from the investigation into the death of Mr. Robert Brooks. Mr. Brooks had been incarcerated at Mohawk Correctional Facility and was transferred to Marcy Correctional Facility on December 9th. During the incident, he was handcuffed with his hands behind his back. He was pronounced dead at Wynn Hospital in Utica on December 10th. I do not take lightly the release of this video, especially in the middle of the holiday season. But as Attorney General, I release these videos because I have a responsibility and duty to provide the Brooks family, their loved ones, and all New Yorkers with transparency and accountability. My deepest condolences go out to Mr. Brooks's family. Under New York law, my office investigates every case in which an officer of the law, including a correctional officer, may have caused the death of a civilian. On December 16th, my office announced that it had opened an investigation into Mr. Brooks's death. As in every case, the attorneys and investigators in my office are conducting an exhaustive review of the facts and the evidence. As Attorney General, you have my word that we will use every possible tool available to us to investigate this death thoroughly and swiftly. As part of the investigation, my office obtained video from body-worn cameras that 4 of the correction officers were wearing at the time of the incident. The 4 officers had their body-worn cameras powered on, but did not activate them. So their cameras were recording video in standby mode without recording sound. My team met with Mr. Brooks's family early.
Look, that's another RICO charge right there, ain't it? Y'all gonna beat them and not even activate your camera? So they didn't even want to let it out. They didn't even know that it was recording. They got caught by accident.
Earlier this week, and they viewed the footage. These videos are shocking and disturbing, and I advise all to take appropriate care before choosing to watch them. We are releasing 8 videos today from 4 officers' body-worn cameras. 4 videos, one from each officer, that each run for the full 30 minute length of the standby mode recording, and a second version of the same 4 videos, which have been cropped to show only footage involving Mr. Brooks and the interactions between the officers and Mr. Brooks. Again, I encourage taking caution before viewing. I want to reiterate that we are investigating this case thoroughly and using every tool at our disposal to ensure that there is transparency and accountability for the events that preceded Mr. Brooks's death. I also want to make clear that this video and the conduct of these officers should not reflect poorly on the work and professionalism of the countless correction officers and correctional facility nurses throughout the state who go to work every day to protect and serve those in their care. And now we will play the 4 cropped videos I mentioned earlier. And all 8 videos will be.
All right, so that was the message there from Tish James. Why I ordered an immediate and full investigation.
Only when they get caught, though. Only when they get caught. And they act like, oh, this is just a one-time thing. Nah, y'all been doing this. Y'all been doing this. Oh, it's this one clip. Dang, I should have grabbed that. Hold on. There is one clip I want to play before we get out of here. Let me run this this news clip real quick and see if I can grab this one more clip before we get out of here. See if I can find it real quick. Appreciate y'all being there. Hit that like, hit that subscribe, tap in, share with a friend.
What is being called a security concern? It's reopened since. Police haven't yet defined what that threat is. They tell us there has been an arrest and the decision to close was out of an abundance of caution. There was a large police presence, as you can see at the mall, with state police even blocking driving entrances. Syracuse Police Chief Joe Cecil will be holding a press conference momentarily. We will get to that in a moment, but first, we're also following a developing story out of Oneida County. The State Attorney General's office just releasing shocking body cam footage showing a graphic portrayal of prison officers punching, kicking an inmate who later died. State Attorney General Letitia James releasing that disturbing body cam video showing the beating that preceded the death of 43-year-old Robert Brooks, an inmate at Marcy Prison in Oneida County. Brooks died earlier this month. News Channel 9's Ashley Caparo now sharing that video with us. Ashley.
Yeah, Christy, the state AG's office confirming Robert Brooks was transferred from Mohawk Correctional Facility to Marcy Correctional Facility on December 9th. Now, less than 24 hours later, he would be dead. I did watch the video, and it's graphic. It shows Brooks being kicked, punched, and at one point partially stripped, all while being handcuffed. Just before 9:30 on December 9th, body cam video shows Robert Brooks in handcuffs being led into the infirmary at Marcy Correctional Facility. Corrections officers are then seen carrying Brooks into the lobby. He is then taken to a medical exam room. There are multiple corrections officers surrounding Brooks. A few minutes into the video, we see the beating begin. Video showing a guard begin punching Brooks while other corrections officers are seen looking on. Video then shows guards holding Brooks down while another guard appears to kick him in the groin. Multiple officers continue to hit and punch Brooks. Video also appears to show a guard grabbing Brooks by his throat and picking him up while another guard continues to hit Brooks in the stomach with a shoe. Now, Brooks was taken to a Utica hospital where he was pronounced dead. He had been serving a 12-year sentence for assaulting his girlfriend. We are also working to learn why Brooks was transferred from Mohawk to Marcy. There were 4 body cams operating, but they were in standby mode and audio was not recorded. Full video released by the AG's office can be found online at localsyr.com. Christy.
Ashley.
All right, hold on. We got this other thing here. I'm just trying to see how I want to play it. This new thread stuff is crazy. I don't know. Some of these apps, I gotta get tapped in with these social media apps, because I don't know what the heck be going on with them half the time. I be feeling old, yo. I be feeling old. All right, here we go. Let me see. Let's switch this to this. Okay, my friend. No sound. All these people randomly getting found with ropes around their neck, hanging from trees. Like, who does that? Who? That's not our types of killing. So that we know that's not black on black crime. But I don't know. I don't think I want to play this.
Found hanging from a tree near a friend's.
Hold on.
Kaiser Jr. found dead near his apartment complex in Charlotte, North Carolina, with a rope around his neck. James Cooper found hanging from a pole in Greenville, Mississippi. Javion McGee, found near a parking lot near a tree in Henderson, North Carolina, with a rope around his neck. And Yolna Lubrin, found hanging from a tree near a friend's house in Orlando, Florida. Kaiser Jr. found...
Who out here hanging people from trees, family? Anyway, I think that's about it for today. For now, let me see. Shout out to everybody in the chat. Appreciate y'all being here. Trakisha in the building. What up? What up? Appreciate you. Juden, appreciate you. Miss D56. Yeah, crazy. That's disgusting, ain't it? Shout out to Miss D56. Brown Sugar Babe. What up? What up? What up? Ain't no way. That's a fact. No one in the building. What up? What up? What up? Appreciate you. Miss D56. Allie. Shout out to our stream sponsor, Allie. And our other stream sponsor, Chan My Black is Golden, always
The
a
absence
stream
of evidence
sponsor.
is not the evidence. The absence.
On the camera and off the camera, always a stream sponsor. Y'all show her some love. Drop them some coins for being the stream sponsors of the night. Appreciate y'all. Brown Sugar Babe. Shout out to the Source, the new logo. You know what I'm talking about. So we're going to be switching some things up. I just didn't want to leave y'all hanging too long just because I'm working on that. So I just wanted to still come and let y'all know I'm still here. Michelle B, appreciate you. Brown Sugar Babe, Trakisha, all y'all, appreciate y'all hanging out. So yeah, man, that's crazy. That's definitely Rico territory though. Definitely in Rico territory. I don't know why they can just get away with doing everything they want to do without no repercussions. Or when they do get a repercussions, it's the minimum. It's the minimum. Even though they should be held at a higher standard than everybody else because that's your job, to protect people, not to kill people. You know what I'm talking about? Why is this up here? Why is it two of me? I can't find the other one. Anyway, appreciate y'all being here. That'll be about it for today. Y'all make sure you hit that like button. You know, I'm reconnecting with the algorithm. I'm like on a 90-day probation type thing, especially with the new name change and all that. It's gonna lower some stuff too, so it's all good. We gonna build it slowly but surely, and then we gonna max up on them. You know what I'm talking about? Nah, but much love. Appreciate y'all. Until next time, stay fresh, stay blessed, and
Have a good night. Have a motherfucking good ass night.
peace out. Go sub up to No One and Rock Solid TV. New stuff coming soon. Shout out to Indigo Kepler.
We'll be fine. Our kids will not be.
Get your money.
Oh yeah, hold up. Before we get out of here though too, hold on. Before we get out of here, hey, y'all go to some of my videos. I was looking for some screenshots to grab, but I couldn't find them. But if y'all go to some of my old videos and y'all see that hype feature on the side of the chat, make sure you slide over and hype it up with some of y'all points. Help us get back in the algorithm. That hype feature makes a big difference. Appreciate y'all, family. Let's go. No one in the chat. Y'all go sub up. Fire music. All right, we out for real this time.